So welcome everybody to What is Your Life Plan Part 2. I'm Melissa Rosenberg. I'm Executive Director of the Howard County Autism Society. We've again had a terrific response and have many individuals registered. I'm sure we'll have some more folks joining us as we go along. We'll be recording the webinar to post along with materials provided by our presenters on our website within the next few days. You'll receive an email once those are posted. Part 1 is already up there along with the last session's materials. We'll also be sending around a survey we hope you'll complete. Just takes about 5 minutes just to give us some feedback on these sessions. Again, please remember to remain on mute and keep your cameras off, and any questions can go into the chat. I want to welcome back our presenters this evening and thank them for again sharing their knowledge and time with our community. We'll also be sharing their contact with you in the chat and on a resource list so that you could reach out to them after the session. First up, we're going to have Jim Curran and Monty Knittle with the Curran Knittle Group, Harbor Investment Advisory. They are certified financial planners who provide comprehensive financial planning and customized investment management for a variety of investors, business owners, and families. They specialize in special needs financial planning. After that, we'll welcome Kelly Nelson from the Maryland Able Accounts, and she's going to take a deeper dive into some of the important aspects of setting up an Able account and all the great amenities that they can offer. And then rounding out the session tonight is Mary O'Byrne of O'Byrne Law. She's going to be talking about estate planning, special needs planning, trusts, fiduciary services, and also guardianship. So I'm going to go ahead and turn it over to Monty to get us started.
Jim usually kick things off, so I'll let you kick them off
Jim,
tonight.
either one. All right.
Okay, so I am Jim Curran, and my partner here is Monty, and we've been working together for, I can never keep track, 10 or 11 years. We came together because of our interest in special needs financial planning. And so we've developed it over that period of time. We're investment people, we do stocks and bonds, but we are financial planning foundation based. That's where things begin. And so we have this, but we do have this specific focus. I would say on this cover page right here to just point out special needs financial planning. And what I wanted to point out was caring for all of your family members. And so a family unit has a mom and a dad, maybe other siblings, as well as, in this case, a child with special needs. And so our approach is to, comprehensive and to speak to the entire family picture, and that would include education planning, retirement planning, as well as leaving a legacy so that your child will be able to continue to live at the standard of living that you've provided for them, over decades and decades. So Monty, if you want to go to that next page, I may have already covered some of that, but.
Sure. So on the next slide, when we're, okay, there we go.
Okay,
Jim?
I'll just give the quick, where we're going to go on this, as I mentioned about financial planning based, and just a couple quick points about that. There's one nest egg, a family has accumulated assets, 401ks, and, fortunate enough, maybe an inheritance or something like that. But there's one nest egg that's going to serve these, multiple goals, other siblings' education, mom and dad want to retire. And so a financial plan would speak to all of those issues about also then, of course, how to plan for to be able to fund, and Mary will talk about trust, but how to be able to fund a trust for the benefit, of your child. And so then Monty's going to get into some detail on a letter of intent. That the next item is, all of this in the context of not compromising and preserving the government benefits that your child is entitled to. We'll get into, how to save there. Kelly's going to talk about Able accounts and touch on family dynamics, which can be a little tricky. And then we'll give you a homework assignment at the very end.
So just real briefly, when folks come into our office and we work with a family, just a quick overview of what are we trying to accomplish? Where do we want the family to go? It's really over 5 areas. And as you can see, the 5 areas are in bold print in the center, and we're trying to essentially move them from the red to the green. And just real briefly, we want to understand the government benefit eligibility of the child and any other appropriate family members, and whether they are eligible or they're not eligible, and when the eligibility will receive, and helping make sure the family does everything in its possibility to maintain that eligibility. If it's an individual under 18, it will be eligible for future benefits. Obviously, core competency is doing financial plans. So we want to understand what has the family done so far in terms of understanding their goals, resources, et cetera. And if they haven't really executed the plan, kind of help them develop that and then accomplish that, deliver the finished product, and help them get on the appropriate track. With legal and estate planning, we're not attorneys. This is certainly an area where we kind of help families understand where are they, what are some of the things they need to get done. Whether it's on the parent level or on the child level, and then refer to somebody such as Mary to help kind of carry the ball across the goal. One thing we're going to spend a little bit more time on later this evening is the letter of intent. It's not a legal document, it's a planning document. And, I can't stress enough for the families that, we work with that have done it. It's one of the things that they really felt a really great sense of accomplishment in getting it done. It's a tool that really you can use for, a positive reason. Maybe, the caregiver is able to get away for a weekend, a week, or whatever, and you just need to, provide some sense of information about your child. Or it can also be used for things that maybe aren't as pleasant, but necessary to think about, is that when the central caregiver can't assume that role in the future with all that stored knowledge in your head and so forth, transferring that document to ensure that the child with disabilities or an adult child with disabilities will have the continuum of care. Then finally, once you've gone through all these steps, it's really about developing that team and communicating it so you can have that future care in place. So, Jim?
Okay. Monty and I put together a 4-step process, which we'll go over briefly. And one of the, at the top of the page there, it talks about complex tasks, and some of them really are complex. The homework assignment I'm going to give you is not complex, though, and but very important. But the complex task also just means a lot of moving parts. And one of the challenges is when you've got like this list of things to take care of, is just to simply get it done. And, with all the best intentions, sometimes that list just sits on the desk because there's so much else going on. And so it's good to have some sort of either professional and or just other person close to you who could be sort of like your partner in doing this. And maybe someone outside your spouse, somebody, from an objective point of view. And but anyway, what you want to do is define, what are the goals? Okay, what are the goals in terms of your child? What are the goals in terms of, if there's siblings, and there may be needs that they have that you want to be able to deliver on. And then lastly, last time I checked, folks would like to retire. Okay, and so when you state those goals, what do we mean by goals? Well, something like, at least in case of retirement, what kind of income do I need to generate to continue to live the standard of living I have been through my working years, which includes taking care of our child with disabilities, living the lifestyle we've been living, and maybe still got to send a kid or two through college. So anyway, Monty. Now, this 4-step process is okay, beginning to put the plan together. All right. And so, item number 1, inventory of assets. Let me back it up a second. A financial plan is essentially a stating of your goals, then an inventory of the assets that you have. Okay, assets include what you've saved, 401ks, all the above, plus Social Security is an asset, as well as if you're fortunate enough to have a pension. All right. And so once you've established the goals, I want this much after-tax money to live in retirement. Here's what I have to work with. And then with those two items, to stress test your ability to succeed in getting to the goal with the resources that you have to work with. All right. And so that stress test is sort of where the bottom line comes in. And so the goals are, hey, I want to retire at 62. Well, the stress test, the stress test is kind of shaky, or, not robust outcome if you retire at 62. So maybe if you continue to work and waited until you were able to receive your full Social Security benefit, you'd be in better shape. So those are the kind of things that are revealed or illuminated. Your savings into 401ks, the risks, the stress test, as I just mentioned, and all the above go into giving you some insight into what, for a lot of people, if they don't have a plan, if you have a plan, you have a better chance of succeeding. And otherwise, you have a vague sense of either that sinking feeling like I'm not where I need to be, or
this is the program,
or even perhaps thinking you're far better off than you are. And so you want to have at least some kind of sense of where you are. It's a point in time look, and this is a very good practice for a family to plan for the future. Monty, real quickly, this is a page out of the book, and you can see the important things are that you see a meter up top that says 43% and a meter up top that says 82%. Okay, those numbers are from a statistical probability software that will, given all that information, the goals, the resources, and the stress test. Stress tests, by the way, are market risk. I think we're familiar with that right now. Inflation, I know we're familiar with that right now. Okay, and then longevity. All right, so those are the risks. And in scenario one, this person has said, I want to retire at 62 and I want this much to live on, and we're going to do all these wonderful things in retirement. They come in at a 43% probability of success, which is below optimal 75% or above. All right. And so, like I said, maybe the suggestion would be, well, if you weren't going to retire at 62 and waited till 67, you might end up with an 82% probability of success. So that's a short version of what, and with far greater detail in the plan. But that's just a short version of something that you could, a conclusion that you could walk away from having done a plan. It might have also said, you're putting 5% away in your 401k. If you put 8%, that would make a difference. There's all kinds of like I said, many moving parts, and this can give you plan can give you some insight into where you stand and what you need to do. Thanks.
Thanks, Jim. So Jim just kind of quickly went over a financial plan briefly. So what we really want to spend some time on tonight is doing a letter of intent. And for those of you who aren't familiar with it, it's not a legal document, it's a planning document. It's really about your child with disabilities and just about who are they, what is the nature of the disabilities, key people, et cetera. Think of this document as, again, as I kind of mentioned earlier, that, if you were to get away for a weekend and Jim and I were to provide respite care, some information that we would need to have on hand to provide the type of care that your child is accustomed to receiving. And then also sort of a future care document, when you can't be that central caregiver down the road, you start to put this together, that all that knowledge you've accumulated over the years, you're trying to transfer so that it's there and available so that someone can come in and assume that role with as little effort as possible and trying to relearn everything. And as you kind of go through the exercise, you do really realize that, if you don't already know it now, and I'm sure you do, that it really is a lot of work. And it may be too much to assume for one person. A lot of parents think that, we've got a sibling who's going to assume that role either in an active or some type of a passive manner. And, maybe that's the case, maybe not, but that sibling may not be able to handle all the roles that you currently are receiving. So it's a really good document, kind of help you understand and pass on the knowledge you have, and maybe try to think more about the future and about the type of care that your child will need and what type of roles and people will be involved. That's kind of what we refer to as the circle of trust. And I said, and Melissa does have the document available, or if you need a copy, please feel free to call or email Jim or I. We'd be happy to email it to you. And when you look at the document, it's 20 some odd pages. This is a lot of work. I know it's important. Let me put it to the side. And certainly I understand that it's certainly not a fun exercise to do, but I can't stress enough that our clients who have done this really have a real sense of satisfaction in getting it done. And it's not as daunting as it seems if you do the preparation. Typically what we've done in the past, and hopefully once we get completely out of sort of the COVID world, we've had sort of a seminars in the office where generally just hand out homework to folks, say, just get this information together, come to our office, have a sandwich, work for an hour and a half, go home, and then 2 weeks later, we do the same thing. So it's really like 3 hours of writing at most. And the people who've taken that, 2 to 3 hours to do that in our office, usually they're getting at least 80% of it done. Most of them finish. So, when you think about the effort put involved, once you assemble the information, writing it down and kind of codifying it, whether you're writing it on paper, whether you're going to do it electronically, that's the easier process. It's just kind of finding the time and being the quiet. And that's the trickier part, I know, for a lot of folks. So in doing the preparation, what we generally suggest is we'll try to do part one. And then we'll go to the next slide, we'll do part two. And part one is a lot of information, which you probably know off your head, things like names, addresses, key contact people in your child's life, medical information, discuss the disability, doctors, et cetera. Prescriptions, I know with my daughter, it's kind of a revolving thing. And, a great idea that a client came up with who was doing her letter of intent electronically, is just took a picture of her phone and inserted it on the bottle of the prescription. So, it has the doctor's information, how often the medication is taken, the pharmacy, everything. So there's all sorts of kind of helpful tricks you can kind of come up with that work for you. But, the guide is simply that. It's a guide to kind of help walk you through getting the key information that you need to get together, kind of assembling it and personalizing that. That's really up to you. Maybe you just want to do it separately in a Word document, or if you're not like me, you actually have good handwriting, maybe you can have a nice handwritten document. The pros or the cons of doing it in a handwritten document is, once this is done, life changes, things happen, your child gets older and things differ. So if you do it electronically and then maybe print out a hard copy, it's much easier to kind of go through once a year, just kind of update the key information. And I'm not going to go over every bullet point on the slide. You can kind of see this information, but this is sort of the information you want to gather. Once you've gathered it, maybe go to a library or someplace that has internet access. If you're going to do it electronically, go to a quiet place, give yourself an hour to an hour and a half, and then just transcribe the information. And it's that simple for part one. For part two, it's a combination of thinking and a little bit less quantitative, and sort of depending upon the abilities and thoughts, you may want to ask the second set of questions. Really have a conversation, with your child and really kind of understand sort of, when you look about if you go towards the very bottom, the goals and aspirations, really kind of getting their involvement in terms of what are their goals, what are their aspirations, and how can we kind of put those down on paper, just not for now, but for sort of future care. So to go back to the top part, the key information, you want to have benefit, the benefits that they're currently receiving, or if they're not receiving, then this is something to do in a couple of years once they turn 18 and to be eligible for government benefits. You want the professional contact information, the financial information. The only thing that I'd suggest adding on here, that's not on this list, is if you are using this for future care and you have a real trusted person involved, maybe write down, do an Excel spreadsheet or something about how are the bills paid, when when the Verizon wireless or T-Mobile, whoever using bill comes in, is it coming in via email? Is it coming in via text? How's that being paid? Credit card bills, the same thing. So you're really just trying to, and really, this is sort of your preference, your comfort level. For instance, I generally pay more of the bills in our house. So in our letter of intent, I kind of include a page for my wife. These are the bills. This is how they come in. This is, the link to the account. Here's my computer password to get on that. And then here's the username and password for each of these. And if, now that everything sends you a text, here's my phone. So in other words, that person has an idea how to pay these bills that came in. In the old days, it was real easy. Statements would come in and say, oh, I didn't know we had a credit card with Macy's or whatever. And you could figure out how to pay it. Nowadays, with everything electronic, it really helps to be organized when you present that. And then as we skip to the bottom part, again, this is really about your son or daughter. I know, at least in my case, my daughter is nonverbal and has limited communication skills. We know where we can pick up a lot of nonverbal skills, but if Jim were to come in and provide us respite care for the weekend, he might not know all those verbal skills, and kind of understanding what are her likes or dislikes. If when she gets upset, what are kind of things that you can do to help her resolve it. What's sort of a daily routine and so forth. So this is a way to kind of really share that information. And again, it kind of depends on the abilities of your child, how much information you really want to put down. And, kind of once you've done this step, you're done, you're completed. I said, maybe 2.5 hours at most of actual sort of typing, writing, however you want to enter this. And, you have it, and you have this information, and then you can share it with whoever is going to be that future caregiver, maybe, or that team of people, or respite care, or however, but you'll have it done, and you really will have a great sense of satisfaction. So, Jim.
Okay. So communication is extremely important on this. And, because there's a lot of, people involved in the care for your daughter. There could be siblings, there could be, communicating with your attorney to make sure things are where you need them to be. And, but you need, like I think I'll just reiterate again the idea of having some sort of maybe accountability partner. You want to use that word, but or that phrase. And but you do want to check off, where are we now on? And this is sort of the little a red zone test that we have at the beginning. But where are we on public benefits? At age 18, your child is eligible for SSI. Prior to that, it is means tested. And then you want to make sure, okay, the special needs documents is really just preparation. Where are the special needs documents? Making decisions about with professional advice from an attorney on guardianship, power of attorney. Monty, I remember you tell me a story one time with talking to CVS on the phone and trying to get a prescription filled for Katie, and it's they want to talk to her, and she's nonverbal, and all these all these kinds of roadblocks you can run into that can be A, frustrating, B, can medications and things, your child needs them. And so then trustee selection, that's huge. Mary will probably talk about that, but a lot of people just do a knee jerk, oh, their brother or sister will do it. Well, maybe, and maybe they're not the best person to do it. The beneficiary review, I'll talk about that at the end. And your attorney will get you up to speed on a lot of these things that are on this slide. Okay, do no evil, which really just means, the road to hell is paved with, good intentions. So your child, you don't want to have the child to be eligible for SSI and Medicaid cannot have more than $2,000 in their name. And just to talk about the good intentions, child can have a grandparent that decides they want to make gifts to the child, and they have no information about this $2,000 limit on assets in your child's name, and so that's where communication, with family members that care a great deal about your child goes a long way. I mean, a grandparent could make a contribution to an ABLE account or to a special needs trust. But anyway, so going back to SSI, you want to get yourself in front of Social Security. SSI, it's kind of an automatic at age 18. But right there where it says Social Security survival benefits, when the parents turn Social Security age, sometimes it's to the benefit for an earlier maybe, than was initially thought, time to register to receive your benefits. So the reason I say that is that could trigger a bump up in the benefit for your child. So that gets complex, and one really does need someone with some expertise in advising you on that. But all of this is really just kind of the gateway into all the other benefits that would be available to your child: housing, transportation, etc. All right, Monty.
Can we grab this one, Jim?
Sure. Okay. Well, Kelly's going to talk about ABLE accounts, and she's going to go into the details of it. But the ABLE accounts are a great deal.
Jim, I think you muted yourself.
Okay.
No, Jim, that was me. I apologize. I hit the wrong button. So you did not do that.
Okay. Which is often the case when I have my IT problems.
Whoops.
I'm the guilty
So
party.
anyway,
I apologize.
ABLE account has great tax benefits, and you'll want to hear everything Kelly has to say about that. Pooled trusts are an interesting alternative to setting up your own special needs trust. There's several in Maryland. One that we've worked with is First Maryland Disability Trust. It pooled, as in you're pooling your assets together with many other families that are utilizing First Maryland instead of opening up their own individual special needs trust. And that can be good for one family. It could be better to have your own individual trust. Mary's going to speak to things along those lines. And she's going to get into this, so I'm not going to steal anybody's thunder, but there isn't one type of special needs trust. All right. Self-settled means it's the person with the disabilities money that funded it. Third party is another person, and Mary will get into more detail than that. So Auntie, you want to get to the next slide here? This is just a visual to demonstrate how many moving parts there are and why it can be daunting if you're just trying to do this by yourself. And everything from to the left, the government benefits, therapists, medical, IEPs, support network, and so on, and to the right, the trust exists, tax returns, attorneys to draw up the documents. What are you going to do with the money once it's deposited to the trust, meaning in the investment manager? What about insurance? Is life insurance part of the plan? Is that a good way to spend fund the trust? And then all of that on the foundation of a good financial plan. Okay, here's your homework. All right. It's all on you to do. All right. And it's really simple. Okay. Anything that has a beneficiary, right? Life insurance, 401ks, IRAs, Roth IRAs, inherited IRAs, annuities, pensions. The financial institution says you have an IRA. Who's your beneficiary? All right. And the financial institution is ironclad beholden to honor whoever that person named as their beneficiary when they pass. It does not matter what the will says. The will has zero bearing. So if you had an IRA with Bank of America or what have you, and it said, your nephew was the beneficiary, and it said, but my will says it's the niece, the bank would say, that's great, but the IRA is going to the nephew because that's what's in the beneficiary document. So what you need to do, okay, or what I'm suggesting you do, is to, people have 401ks from 2 jobs ago. All right, they have inherited IRAs, all these various things where beneficiaries are named, and you may have a beneficiary listed that you really would prefer not to be the case now. So as in maybe an ex-spouse could be the case. But the real why this is really important is, say you put beneficiaries, I have 3 children, and one would think, and one is a child with disabilities, one would think, okay, well, it'll be 1/3, 1/3, 1/3, and so you name your 3 children. But that's going to cause a problem, because your child with disabilities cannot receive money in their own name. Remember the $2,000 rule? So what you would want to have is child number 1 by name, child number 2 by name, and not child number 3 with a disability, but the special needs trust for the benefit of that child. It's how it has to be titled. That way you don't run into any trouble with SSI, Medicaid, and those government benefits that you do not want to compromise. So you can do this on your own. 401ks, you can go on the websites, change beneficiaries, and you might have to make a phone call or 2, but it behooves you to do it. And the older the entity, the plan, the policy is, the higher the likely or probability or chance that there'll be a beneficiary listing that would not be good. So that's it from us, I think. Monty?
Yeah, we just have one question written down about an individual who has more than $2,000 in the rep payee account, and are they eligible to move that over to an ABLE account? And yes, you may do that. And other than that, thank everybody.
Thank you. That was me. Thank you very much.
You're welcome. I guess that wraps us up, Melissa.
All right, great, very good. And there's the contact info, and I am going to share that with everybody. Okay, next we're going to invite Kelly Nelson from Maryland ABLE. So I am going to, Kelly, I'm going to make you co-host here so you can share.
All righty.
And Monty can stop sharing.
Okay. Well, good evening, everyone. I'm Kelly Nelson, the Outreach and Communications Manager for Maryland ABLE. And if I seem a little excited to be back here again with you guys to talk about ABLE accounts, it's true, I am. I might have shared last time that in addition to working with the Maryland ABLE program, I'm also a parent of an 18-year-old daughter with multiple disabilities who has an ABLE account of her own, and I serve as her authorized legal representative. So I have some practical real life experience. So I thought, since I had this opportunity to come back and talk with you guys, I would select some of the features that I mentioned last time, but really didn't get a chance to get too far into the weeds about, and talk about those, because I feel that, over the last several years, these features have really helped our daughter to, she's really grown in her independence, become more self-confident, practice some personal choice, and these features have helped. It's also been a helpful feature for us, the savings and investment option for her father and I to be able to begin that process of planning and preparing for her future. So that's going to be our focus of our presentation. But before I do that, I'm going to give the fastest ever reminder overview about ABLE accounts, and then we're going to move right into the features. Just a little reminder that the main reason why people open ABLE accounts are because it gives people the opportunity to be able to save beyond that asset limit, that $2,000 asset limit that is associated with people who are receiving SSI cash benefits. So the ABLE legislation made that possible because you're actually able to save up to $100,000 in an ABLE account without impacting those benefits. And also, in addition to not losing the actual SSI cash benefit, but you're also able to maintain your Medicaid, that's your insurance, and any waivers that would be attached to that. Things like the food, energy, and housing assistance. These waivers are so hard to come by. So we never want to have a situation where we've accidentally overlooked our resources, become over-resourced, and didn't take care of that, and had either a pause or a delay or a loss of these benefits in any way. The other reason, and I believe Monty did mention this, that there is tax advantages as well of having an ABLE account. The first is that ABLE account owners are not going to be paying any state or federal taxes on their earnings, not while the money's in the account and not when it is taken out either, provided that you're using it for qualified disability expenses, which is basically anything, any service, any item that supports the account holder or the beneficiary in his or her health, independence, or quality of life. So you have so many options of how you're able to use that money. The other tax advantage is that you can take advantage of an income deduction on your Maryland state taxes. If you live in Maryland, pay Maryland taxes, whatever you contribute to your ABLE account up to $2,500 per person is eligible for an income deduction. So for parents that are married and filing joint, they're able to take a $5,000 income deduction if they were to contribute that much money to their child's ABLE account. And what a wonderful incentive and a way to get started is you want to do this anyway. You want to begin that planning and preparing for the future, but now you have also an extra benefit of being able to lower that income on the Maryland state taxes. ABLE accounts can be set up online. Usually if the person is under the age of 18, it takes about 15 minutes from beginning to end. So it's pretty easy to do. A little bit longer if you're opening for an adult. If you have an adult child, someone that's over the age of 18, we require that person give consent for someone to serve as their authorized legal representative. And that could be a power of attorney that you've had developed with your estate planning attorney, or it could be a guardianship papers if you have those. It could also be the form that we have available on our website, which is a limited power of attorney over the ABLE account only. So it's just something that you would take to a notary and have signed in the presence of a notary, you and your adult child, and in the presence of the notary and 2 witnesses, and you could upload that as well. So those are the main reasons why people are open ABLE accounts. And real quick, I just want to talk about the savings versus investment options. You know, we might have gotten into this a little bit, but we didn't get too far into the weeds. I just want to remind folks that you guys have options. When you have an ABLE account, your funds can be put into the cash savings option, which is similar to an FDIC insured banking product, okay? Because it's insured up to $250,000. You'll be receiving whatever the federal interest rate is at the time. Sadly, it's been very, very low for the last couple of years, but that's the way it's set up. You know that your money is pretty safe because it's insured up to $250,000. However, the interest that you're earning is not so great right now. But for some folks, this is a great option because they say, hey, listen, I'm putting money away into my ABLE account, excess money from my SSI, but when I need it, I want to get to it right away. And I want to know that it's going to be there instead of, putting in an investment option where I'm taking some risk with my money. So for many folks, that's a great option. For those who want to think about using ABLE accounts as an investment tool, we do have, oh my goodness, I don't know how I wound up with the wrong slide deck up on here, but I sure did. We actually have 4 investment options. And the first one is our fixed income option, which is our newest new investment option, where it's 100% purchase 100% bonds. So it's not as volatile as the stock market is. You've got a little more stability there. You're not going to have quite the earning potential that you would have if you were investing in a portfolio that was a mixture of stocks, but you also don't have the risk as well. So this is a great tool for someone who wants to maybe try out some investments and make a little bit of money without too much risk. The other options are our conservative, moderate, and aggressive portfolios. These are all, again, going to vary upon how much risk someone wants to take with investing their money and how long they want to leave it in, you know. So our conservative option is great for folks who want to just experiment with some investments, because we've got 20% of that portfolio is in the stock market and 80% in bonds. So you're going to have a little more earning potential, perhaps, because you've got the ability to earn more from the market. However, again, and if anyone's following that, you know how it's been pretty volatile lately. So just something to think about. The moderate is a mixture. It's actually a 50-50 split between investment in bonds and the other 50% in stocks. And the aggressive option is 84% that's going to be in stocks, with just 16% in bonds. So much higher risk, usually higher earning potential. Usually these are folks that want to leave this money in that investment option or that investment portfolio, pardon me, for longer periods of time, because they're willing to just kind of ride out those fluctuations. But again, really, there is no right or wrong answer. It's just a mix of whatever works best for you, your family member. That's what you want to consider. This is where you see the value of being able to consult with a financial planner, because they can help you assess what might be the best choice. Know this, that you have options, and that every time you make a contribution to your ABLE account, it's going to give you the option of where you want to put it. And, you know, last year or in previous years, we had, when you open the ABLE account, you would enroll and you would pick a percentage. You would pick your investment options, this much in cash and this much in investments. But now we have it so that every time you make a contribution to your ABLE account, you have a choice of choosing one of our 4 investment options to put the money in, or the cash savings option. So you don't have to always make the contribution to cash. You can put some in one of the investments if you want. So lots more flexibility to just know that that's available to you. The other thing I want to talk about is, pardon me, the prepaid card option. So we do know that the way that you can access funds that are in your ABLE account is through that linked bank account. You enroll in an ABLE account, you choose which bank account, existing bank account that you have, whether it be a checking or a savings, that you're going to link to your ABLE account. So that's how you get funds into your account, and that's how you withdraw funds from your ABLE account. We do have another option, which is our prepaid card option. This is not something that automatically comes with the ABLE account. There's an additional fee of $1.25 per month, but it's all about the convenience. But really what I want to talk about more is how it can be used. For those of you who have younger children, it's a wonderful tool to teach some financial literacy skills. You know, young people in general are just learning about budgeting and spending money and saving money and the cost of living. I mean, how could they know? They don't have that much life experience yet, right? So we were able to utilize this prepaid card with our daughter and give her a card of her own so that she would be able to make some choices about how she wanted to spend some of her money. It's giving her a chance to kind of practice. You know, nobody turns 18 and poof, we know all the answers about how to save and spend. So we got this ABLE card for her several years ago. And if you've heard this story before, pardon me for sharing it again, but it was a learning experience from the minute she got it. She opened it up and she was so excited. She said, "Oh my gosh, I got my own credit card like my brothers and my mom and my dad. Give me my phone. I want to take a picture of it and I want to send a picture to all my friends." Now, we all know that we should not be sending pictures of our credit card numbers over the texting and giving these out to our friends. But wow, that was the first lesson that we had. we don't do that and why. But beyond that, it's given Lily an opportunity because you load this card with funds from the ABLE account, and she has some choice on how she spends money from the account. You can use it online or in the community. So she's been able to do some things for herself, like purchase her own school supplies. If she goes out to, when she went to a field trip, or one of the places they went to, they had the opportunity to stop and have lunch somewhere on the way back. So she had her prepaid card with her. We didn't have to worry about, did we send enough money for this restaurant? What are we going to do? She had her card. She was able to make those purchases. But beyond that, because the ABLE prepaid card has a nice little reporting system, it gives you a chance to see how you're spending your money. And there's that balance that's on the card. So we linked the card for some payments, like to her prepaid phone bill with AT&T. So she's learning about the cost of living, the phone that you use, it costs money to use it every month. And just learning about how some of the things that come off of that card are things that we consider needs, like maybe her prescriptions. And some of them are fun things, like if she wanted to go and have lunch or something like that. These are things that you're learning about needs versus want, and how much money is left on my card. Do I have enough money to make this purchase? So a really good tool for that, something to consider. And the other thing is I'd like to share is the gifting page. I think this is probably one of our most underutilized features with an ABLE account, but it's a fantastic way to have family and friends support your family member in their saving and investing goals. It really is. So what you do is you log into your ABLE account, and from your dashboard, you can click on the activity page, and you can set up your gifting page and launch it. And you determine how much that savings goal is going to be that people could contribute. And from there, you can send that page link by text, Facebook Messenger, or email to any of your family and friends, and they can help you in reaching your goals. I've seen this used in some fantastic ways. People saving for a special trip that they've always wanted to go, a special vacation they wanted to go on, or they're saving money for their first vehicle. They've been able to move out and get their own apartment. They're saving money for some home goods or furnishings. So really great ways. It's a nice tool for family and friends. Instead of buying them another video game, they could make a contribution to their ABLE account for birthdays and holidays, and they're able to make a tax deduction. So these are some really great tools just to think about. I'm sticking around for questions. That's all I'm going to share with you guys tonight. And I'm going to go ahead and let Mary bring us home down the home stretch.
Great. Thank you, Kelly. And I know we have some questions for you once we get through with.
Okay.
All right. Where are you, Mary? Mary. There you are. Okay. All right, Mary, you are the co-host.
Okay, thank you very much. And all right. Come on, slideshow, let's go. All right. Great. Well, it's lovely to be with you all again this evening. We started out back in January when it was cold and dreary, and now it's lovely and sunny even still at this hour. And always a pleasure to be able to be on a panel with Jim and Monty and Kelly and Melissa. Thank you very much for the opportunity to come back and speak with folks. I'm going to refer you to my materials from the January program for a pretty detailed discussion around estate planning and use of trusts and so forth. Our charge for the second session here was to drill down into a level of detail that I really felt was going to be helpful for people to drill down into guardianship in particular. So that's where I'm going to be focusing my my comments tonight. And I wanted to say thank you very much to the Howard County Autism Society, being courteous in my thanks to Melissa and company. In our last program, I spoke broadly on the general topics that you see arrayed here on the screen, and how they interrelate in terms of planning, particularly for a young person approaching adulthood, a young person with disabilities. I'm going to be focusing on the upper right corner here of this graphic, which is around supporting decision making, and in particular on guardianship and distinguishing that from different alternatives. And like I said, to take a pretty detailed walk through the process of pursuing guardianship. It's been my experience working with families over the last 25 years that those with young family members with disabilities have some pretty common goals as they are anticipating their child becoming an adult, and goals around wanting to continue to be engaged in decision making, that they really want to be supportive of their child's autonomy and independence and ability to make their own decisions, and they're looking to have a legal, meaning a recognized role in being allowed to take part in complex decision making. And I think all parents want to protect their kids from being manipulated, from being taken advantage of financially, and they want to remain involved in important decisions as their child grows older. And we have available to us a lot of ways that people can do that. The parents can be involved in decision making, both on the financial and the medical side. And we're just going to take a quick look at some of those. For example, if the young person is capable, if they're able to understand and wish to take advantage of legal services like the preparation of a financial power of attorney, that gives a way for someone to be able to be involved in financial decision making through a decision and action by the individual with disabilities themselves. We may have somebody who's a representative payee for Social Security or VA benefits. The ABLE account, as Kelly was describing, is another way for that authorized signer to be involved in how the ABLE account is used and funded and so forth. A trust is another way in which people can be involved in managing financial assets. All of these are alternatives to guardianship, and often these tools are sufficient for the needs that we face, but not always. On the medical side, again, if the young person is capable and interested in doing an advanced medical directive, and when I say capable, that's able to understand the notion of giving instruction and permission to others to be involved in one's decision making, also have to be over 18. That's a key part of it. But if your adult child with disabilities aren't able to understand notions like the medical directive or a financial power of attorney, we do have some alternate ways under statute for family members to be involved in medical decision making. And for that, we look to our surrogate decision making statute, which recognizes that if we have someone who's not capable of making an informed medical decision and they haven't appointed a healthcare agent, or they're not able to, or the agent isn't available, and if they don't have a guardian, then we are able to look to other people in a familial relationship who have authority to be able to make decisions. And you can see that on our list here is a parent of the individual or an adult brother or sister. So we have this vehicle to be able to allow family members to be involved in medical decision making. But even with these alternatives, sometimes there are even simpler options available to us that often are overlooked, and one of those is consent. That the individual may consent to a parent or other family member being present during medical appointments, or consent to sharing information. And while this may not be as broad in authority as an advanced medical directive or the surrogate decision-making power, it can be a helpful way to smooth the ability of a parent or other family member to interact with medical providers. something that's very, very new on the scene for Maryland, and just a terrific step on the part of the General Assembly is supported decision making. And I should have put quotes around that, because supported decision making is a particular sort of approach to decision making in which an individual is able to gain the assistance of people who support them in figuring out what they're trying to decide, what their options are, how they might weigh decisions, very much like the way we make decisions, right? I mean, this is something that's quite universal. But to recognize the validity of decisions that are made in the context of this somewhat structured process that enables people to make and communicate and carry out decisions using support from people whom they trust. This has been signed into law, but it won't become effective until October 1st of this year. And you can expect to see probably a lot more information out about supported decision making and what this means for your family members. But it may be that even with these tools, your family member situation really is not fully addressed, that these alternatives may not be sufficient for the kinds of support that someone might need. And in that situation, after we kind of eliminated these other alternatives, then we're really looking at guardianship. And the rest of my comments this evening are going to be about around illuminating, shining the light on parts of the process of achieving guardianship and what that means, both in the process before the court, but also in the long run. So guardianship is established for purposes of managing someone's property, or for making medical decisions and other more personal decisions, or both. So we can have a guardian of property, a guardian of person, or for both. And I'm going to give you a pretty high level overview of the guardianship process. And I'm going to have a little disclaimer in just a second, just to clarify that this isn't meant to be an exhaustive list, but an opportunity to help you appreciate what's involved in going out, sort of pursuing this process. So at a high level overview, I've sort of started with assessing the alternatives, those options that I discussed before. And then our next step is going to be around preparing the request to the court to appoint a guardian, and what it takes to complete that process, and what you have to prepare and submit. And then we're going to talk a little bit about the kind of protections that our judicial system offers for people who are, for whom a guardian is being sought. And you'll see the phrase in quotes there, alleged disabled, which is sort of well, it's kind of an awkward legal term, but the person for whom the guardianship is being proposed is referred to as the alleged disabled. And in this context, a legal context, disability means something quite specific about decision making. The next big step involved is a hearing. There's always a hearing when a guardianship takes place. And then we're going to talk a little bit more about what happens after the court issues an order. And it's important to remember that getting the order from the court that you have been appointed as the guardian is really the beginning of a long-term process and relationship with the court. It's not the end. So this is my little cautionary slide that says, I'm not trying to provide a comprehensive step-by-step set of instructions for becoming a guardian, but to give you some examples of the forms that are used, and to have a sense of the perspective of the court in this process of appointing a guardian. It's absolutely vital that you take time to carefully review the website on the Maryland Judiciary website, that is the particular pages related to guardianship. And I give you a link to that later in my materials. And it is not required that one have an attorney to seek guardianship. Sometimes people do wish to do so, and you might want to consult with someone about understanding whether you would want or not want to have an attorney assist you, but it's absolutely not a requirement. So we start with, how do we ask the court to appoint a guardian? And I've been referring to the court. The guardianship process takes place in our circuit courts here in Maryland. It is a judicial process. It is a matter of public record, and there are specific instructions and processes and reporting requirements that go along with it. We start by a petition to the court. That petition is the request. This is how we say, we think somebody needs to have a guardian and here's why. And as you see from this example, and we'll have a couple of slides for each of these documents, you may seek guardian of person, of property, or both. And among the things that you should be aware of when the court is considering appointing a guardian, as they think about whom to appoint as the guardian, that they want to know that this is someone who is trustworthy and will do a good job. And so one of the things that they ask, and has to be stated in the petition, is whether or not you've ever been convicted of a crime of a financial or sort of fiduciary nature. And if you have, then you are obligated to report this, but you also have the opportunity to say, but that shouldn't rule me out as a guardian. And another important feature of these petitions is that you have to provide a list of all of the interested persons. Interested persons is a term defined in our statute, and this means anybody who is an heir who legally would inherit from the alleged disabled if they died. So that means parents, it means it may mean siblings, it may mean offspring of their own. So that notion of interested persons being given notice is sort of again speaks to this is a matter of public record. And those who have a close familial relationship with the person who is considered the alleged disabled have a right to know that this process is underway. This is very important if we may have a situation where there's been a divorce and the parents may not be in communication with each other, may not be getting along with each other, but both parents, for example, are interested persons. And if one parent seeks to be appointed as the guardian, they must give notice to the other parent, among others. The court wants to know about other people who were involved in the person's life and wants to know who they are, where they live, and what their role has been. They want to know where has this person lived over the last 5 years, and they want the names and addresses and the dates. The court's interested in your own description of what you think is the basis for there being a guardian appointed, whether for person or property, and there's an opportunity for you to provide that information. And so that petition is how we ask the court to appoint a guardian. But the whole point of underlying a guardianship is that this is someone who is determined to be not competent to make decisions. So then the question is, well, how do we demonstrate that they're not competent? It isn't enough to give your opinion. Your opinion is helpful, but it's not enough to persuade the court. So to demonstrate lack of competency, we have to get certificates from medical or clinical providers, a physician, a psychologist, a social worker, or a nurse practitioner. At least one of these must be a physician. And in fact, we need 2 certificates, at least one from a physician and the other from one of those other, it can be a second physician or psychologist, social worker, or a nurse practitioner. These certificates, and this is included in your materials, are quite detailed. The court wants to know, okay, who are you, clinical provider? What's your background? What's your training? How do we know that you're able to make a thoughtful assessment about somebody's capacity to make decisions? So the provider has to identify themselves and explain their credentials. They then have to report on the degree of investigation that they conducted in assessing the person's competency. And so they're asked to report, when did they meet them? For how long did they meet them? What tests were performed? How did you interact with a person? There is a provision for being able to meet remotely, just, in light of the last couple of years. They're asked to provide a detailed report on the physical condition, again, what sort of tests or evaluations were made, and then to discuss in detail the nature of the impact on decision-making, whether they have a mental condition, that is to say a mental illness, whether they have a cognitive impairment that might relate to developmental disability, the court's looking for a lot of detail. I've highlighted here, these items that you see in yellow are my highlights, not the court's, but it's an opportunity for you to be aware of, this is the level of information the court is looking for. One of the important features about the certificates is that one of them must be really, really recent, has to be really hot. One of these certificates has to be no more than 3 weeks old at the time the petition is submitted to the court. So that's an important thing about your timing and gathering information as you proceed in the process of seeking guardianship, is the timing of when you are seeking to get these certificates, so that you don't run out of time in submitting the petition. We have a couple of important features in how we protect the rights of the alleged disabled, because guardianship is really an adversarial process. It does involve taking rights away. So first, it's important to know that the court will appoint a lawyer for the alleged disabled, and for your child, if they don't have a lawyer of their own, and your lawyer can't be their lawyer. Okay, they have a right to counsel of their own. And I'll note that if your child has financial resources, they can be expected to pay for that counsel. But the court's going to make sure that there's a lawyer there to stand up for them in this proceeding. The other is that there will always be a hearing in a guardianship proceeding. Always. This takes place in open court. And that, in fact, the alleged disabled has a right to appear in their own hearing, and even to have a jury trial. Now, it's not uncommon for the court-appointed counsel to waive those rights if they feel that the individual is not fully able to express their wishes. But these are examples of protections for the person for whom a guardian may be appointed. If all goes well in that hearing and in the documentation before, the court's going to issue an order that appoints the guardian. What's really important to understand here is that it's actually the court that is serving as the guardian, that it's been proven sufficiently to the judge that a guardianship is appropriate, and the court's actually delegating to you to serve in the role that we call guardian, but it's actually the court that remains in control. The order is going to be your document that allows you to make decisions to prove your authority. There might be limitations imposed in that guardianship. There might be the need to return to court for certain decisions, such as moving from one type of abode to another, or making certain kinds of medical decisions. The order is also going to be your guideline in terms of reporting obligations, because there's a number of obligations that you have once you've been appointed. One is that there's training that you're responsible for completing. This is generally can be done online. Local courts may offer the training in person. There's an orientation video which you have to view and certify that you've seen before you're appointed as the guardian. And then there are the actual training videos. There's one for guardian of person, one for guardian of property, or there's one that you can view for both if you're appointed for both. And again, you have to timely file a certificate to the court saying, yep, I did my training. I've taken care of that. And also, you've got to file reports on a regular basis. Again, it's the court that's the guardian here. You are really serving as sort of the delegate from the court, sort of the court's agent. And the court wants to keep an eye on how things are going for this individual who has been determined not able to make their own decisions, and for whom somebody's been given the responsibility for looking after them. So you need to be prepared for an ongoing, really a lifelong reporting relationship with the court. The first that's required is an inventory and an information report that identifies what assets the individual has. That has to be filed within 2 months of the appointment. And then on an annual basis, and it's timed to the anniversary of the court order plus 60 days. That magic date is the date by which the guardian has to be filing the annual reports, whether of person or for property. I include an example of the inventory and information report here. It's pretty detailed about what the person's assets are, what their income is, whether they might be expected to be coming into other wealth, for instance, from a personal injury matter, or from insurance, or from an inheritance. It's a very detailed report about the person's financial situation. And again, you can see that that's got to be filed within 60 days of the appointment of the guardian. I'm just going to sort of roll through this one. And this includes things like, what's their health insurance situation? Do they have any other interests in property that would be less than a full ownership? Do they have an interest in a corporation, in a partnership, or a life estate interest? Those might not seem quite so common for young people, but sometimes families have complex financial situations, and young people may in fact have these rights. And that's an example of something that does need to be reported on the inventory. In terms of the annual reporting, I want to take just a moment and really focus in on the annual report of the guardian of person. This report reveals the amount of record keeping that the guardian of person has got to keep so that they can complete this report every year. The court wants to know the things you imagine, like where are they living, have they moved, but more importantly, they're going to ask, what medical professionals did the disabled person visit during this period? Who did they visit? How frequently? When were they seen? That's a lot of detail. What medications are they taking? What dosages? And what's the timing for that? They want to know if there's anything happening in terms of their education. Are they going to school or are they working? They want to know about the person's social activities. How are they spending their time? Who's involved? Who visits? The court really is interested in knowing on a regular, meaning an annual basis, how is this person doing? Are they thriving? Are they well? Are they being looked after? And it's important that you be familiar with the extent of this reporting so that you can be prepared for being able to prepare these reports. This also asks if there's been any changes in the person's ability to make any decisions about their health. If the person had been under a disability that may have changed over time, if their thinking became more clear, if they became able to make decisions that they couldn't make in the past, that may be an argument for a change in the guardianship appointment. They also ask about the guardian's health. Like, how are you doing? You still okay? Can you still do this job? Can you still keep track and look after this person? Is it time for you to step down and have someone else appointed? So this is a very comprehensive kind of report that the guardian's got to file every single year. On the financial side, we call this the fiduciary's account. And this actually very closely mirrors the inventory that I showed you a few minutes ago in terms of identifying in detail the financial and sort of other sorts of interests that the person might have, what the totals are, and how funds have been spent on their behalf. Being mindful of our time to be able to allow time for questions, I am going to sort of jump to, here's some suggestions as you are thinking about moving forward with guardianship. You really want to think through those alternatives to guardianship because the court will want to know which of those have been tried and why they weren't sufficient and why guardianship is really necessary. I urge you to familiarize yourself with the website, again, it's, I think, on the next slide, with the rules and the forms and the process. The website that I'm referring to is really, really well done. The Maryland court system in the last decade has devoted a lot of energy to improving the guardianship process and the quality of the materials and the quality of the court's oversight. You'd really want to take advantage of that. If you have questions beyond what you can answer on the website as you're thinking about pursuing guardianship, you can contact your county circuit court. Many of them have a guardianship attorney, someone responsible for looking over that process. There's a lot of information to be gathered in advance of preparing the petition or the reports, and this is again a good model for being able to take good care in your record keeping. And let's see here, ta-da! Here is the link to the Maryland Judiciary website. This is really the keys to the kingdom in terms of understanding the resources available and the process and so forth for guardianship. All of the necessary forms for filing guardianship are found here, and as well as quite a lot of other useful information. This is also where you would access the training videos. with that, I'm also just note that there are other resources that may be of help to you as you think about guardianship for your loved one. And also I'll point you to, in particular, to the last item here, the publication Planning Now that is published by the Maryland Developmental Disabilities Council has a great section about guardianship and alternatives. And with that, I will say thank you. And Melissa, back over to you.
Oh, thank you, Mary. Such great information. We appreciate that. We do have a number of questions in the chat for all of our speakers. So I'm gonna scroll back and start. These next couple are for you, Kelly, on the 529. Is there a match like the 529? Could I keep the 529 match and then roll it over?
So if you have a 529 account, you can roll over funds from your ABLE account into, as long as the 529 account is the beneficiary is your family member with the ABLE account, you can roll funds over into the from 529 to ABLE. Just remember, you still have to abide within that $16,000 a year annual contribution limit. So you can definitely do that. As far as a match, currently, we're not aware of anyone that's doing that, but we want you guys to know that Maryland ABLE is actively reaching out to employers, large employers, small employers, all employers, to say, hey guys, please make ABLE account information available to your employees and consider making a match contribution. So far, we haven't had anyone bite on that, but if you have an in with your organization, we're happy to help you let them know how it benefits.
That's great. Thank you.
Mhm.
From Mark Howard, are these funds indexed funds or managed funds?
So they're they're mutual funds managed by Vanguard.
Okay. And then can the money in the ABLE account be moved between funds, interfund transfers like with the TSP?
So you can move funds from one investment option to another. Just know that you can do that up to twice a year. So it's not like you go in every month and switch them back and forth between aggressive to fixed income, but you can do it 2 times a year.
That's great. Thank you.
Mhm.
And can my daughter over age 18 have the ABLE account set up only in her own name?
Yes, it's important to remember that ABLE accounts are always owned by the person with the disability. So the ABLE account will be established in that person's name, even if they're an infant, okay? The difference is whether they need someone or want someone to serve as an authorized legal representative. So my daughter's ABLE account is in her name. I'm listed as the authorized legal representative.
Thank you. Is the surrogate decision-making alternative enough medically, financially, and legally in an adult without the presence of any other documents?
That's a great question. The surrogate decision-making structure that we have under our state statute is only about medical decision-making. This is a statute that allows people who are in certain familial relationships to have the legal authority to make medical decisions and get information for someone who isn't able to make an informed decision, who doesn't have a guardian and doesn't have a medical directive. And so this structure, which is very useful, is only in the medical context. On the financial and legal side, we have more choices, but each one of them is sort of more narrow. For example, somebody can be appointed as a representative payee for their child's SSI or Social Security income. But if your child comes into funds from some other source, if they have an injury and they get an insurance settlement, your representative payee status doesn't help you with that. That money doesn't have, may not have another way for it to be handled. And so in determining what options are available and what fits, we have a range of choices, but each one of them, again, on the financial and legal side, has some limitations. We don't have an encompassing statute like we do on the medical side.
Thank you very much. Okay. Oh, I see. Okay. Jamila was asking back to the question about the state match. Jamila, did that answer your question? Is there a state match? if you're a state employee?
Currently,
no,
there's
nothing.
not a state.
We're gonna
match.
work on that.
Yeah. Mhm.
All right, and I will send the attachments for this program like we did in January, exactly. Give me a few days. We usually clean up the recording a little and then send everything out. I did put the link in the chat from the last session. Tim has two questions. One is financial. My son is so high functioning, he's working full-time at a wage, lost his SSI payments. How does that affect financial planning? And the second is legal. Should an adult disabled person have his or own will? Good questions. So start with the financial.
Well, so the SSI, because of your son's income, is something that's no longer available to him. That's not to say that from a financial planning standpoint, that it can be a very important part of the plan to make sure there is a legacy there for his benefit. And then Mary could maybe speak to this, but maybe perhaps not need specifically to be a special needs trust, but a trust of some sort could be established. Want feedback from Mary on something like that, but from financial planning from a long-term perspective, I do think, Monty, you can jump in here too, but as far as like Medicaid goes, with assets over $2,000, not be eligible for that also. But if, as you said, your son was diagnosed before, Kelly, I don't know if it's still age 26, with a disability, some of his income up to $15,000 a year could be contributed to by him to his ABLE account.
Well, I have an ABLE account. I've had an ABLE account since they were first created by the state, how many years ago. And I also have a special needs trust that I created in 2011. That's a secondary question I'll just talk to you personally about. But
Can I also jump in on this one too? Just
yes, of course.
the SSI benefit is so modest. It's $841, and so it doesn't take much income to knock you out of SSI. But that income that your son is earning may or may not be enough for him to live on and flourish. And so even if he's not knowing what his actual circumstances are, I just note that it may still be valuable to be protecting funds for him to ensure that there's a mechanism for managing funds, that it's protected from his creditors, that there's a management vehicle that might still be worthwhile. Also, I'll just note that for folks who may, because of their employment, may lose their SSI eligibility, there's a couple of vehicles to be able to keep his Medicaid coverage. The Employed Individuals with Disabilities program is one Medicaid medical assistance program specifically for people who are employed and may have lost their income benefit, but it gives them a way to be able to keep their medical assistance health insurance, which might be really valuable too. Your second question about, does the adult disabled person, should they have a will? Absolutely. If they are capable and willing and interested, it is so helpful for all adults to have basic legal documents: power of attorney, medical directive, and a will.
Thank you, guys. That's great. Kelly, it looks like you answered Jamila's question about the 529. She can keep the 529 for now, since that is matched, correct? I'm assuming that's matched. Okay.
But again, if the person is the beneficiary on the 529, that could be considered an asset when they receive that. No.
Sorry to contradict you, Kelly.
No, as I said, could be. So I just, I want to make sure that, to check that out, to make sure that if they're the beneficiary and receive those funds. So Mary says no.
The 529 is, from the point of view of SSI and medical assistance, is considered to belong to the custodian. In the 529, it's a little different from your program because the person isn't the owner. They're the beneficiary, but they're not considered the owner. So if the parents have created and funded a 529, it's not considered to, and their child is the beneficiary, the child isn't considered to own it. And so it doesn't impact their SSI or medical assistance financial eligibility.
Thank you so much. Can funds in excess of the $100,000 ABLE limit be deposited into the special needs trust?
So once you have the money in the ABLE account, you have to use it for qualified disability expenses. So we are aware of people that fund the ABLE account from disbursements from a special needs trust, but we don't see it usually going the other way. So I would, instead of having to worry about a $2,000 balance, if you're getting close to that $100,000, opening up, having that special needs trust to put in money that you would want, so that you don't have that account balance go over $100,000 would be an option.
Thank you. Good.
Okay, thank you.
Do we have other questions? We're coming up to our 8:30 time. This has been great, you guys. Thank you so much. I want to thank Jim and Monty, Kelly and Mary for coming back and being on with us tonight. And oops, one last question here. Does the special needs trust subject to Medicare payback? Am I reading that? Am I saying that correctly? Jamila, why don't you unmute and go ahead and.
Sorry, I was told that if the person is receiving Medicare, that if they inherit anything, they could be subject to Medicare payback, like upon, like if they die or something, instead of it going to their estate.
If I can jump in on that one, there, in the realm of special needs trusts, we have third-party trusts, which are those funded by family members or anybody other than the beneficiary. And then we have first-party trusts, which are funded by the beneficiary who may come into assets of their own. It's only the first-party trust which has any payback provisions, and that is to pay back the state Medicaid programs, which have provided benefits during their lifetime. It's a slightly different rule for pooled trusts. So Medicare, which is our federal health insurance program, isn't in the sort of the payback picture at all. If someone came in to fund, if they received an inheritance, for example, that wasn't in a trust, they have options of what they can do with it. They could put it in an ABLE account or a first party special needs trust, or they could spend the money down. It wouldn't be subject to a claim or a clawback by the Medicaid program. Now, if somebody has a personal injury settlement and they were injured and they received medical care through Medicare or Medicaid, very different scenario, but that may be getting a little too into the weeds.
That's great. Thank you very much. Jamila, did that answer your question?
It did. Thank you.
All right,
Okay,
great.
good.
Jamila's getting a jump on things. She's got a young.
I already have Mary on my list to contact.
I'm
her.
telling you, no, it's smart.
I'm a lawyer and I've done estate planning, but this special needs stuff is like totally different language for me, and I don't even want to mess around.
Good. That's great.
Give me a
Well,
call. Happy to chat.
That's good. That's great. Thank you all again. Mary, Jim, Monty, Kelly, we really appreciate you being on. This, again, we'll be sharing the recording and the materials in just a few days. Session 1 is already on the website, along with all of our past webinars from the last couple of years. So thank you very much. And we'll see you next time. I think we'll be back in the fall with another webinar series. So thank you guys.
Thank you.
Good night, everybody.
Good evening, everyone.
Thanks, all.
Thanks for coming out, everybody.
This has been
Bye-bye.
so helpful. Thank you so much.
Great.
Thank you.